ask you a couple questions regarding today's hearing, Ms. Watkins. And if you don't understand my questions or need to repeat questions, just let me know and I'll do so.
Okay.
Okay. So Ms. Watkins, I'm just gonna get straight to the chase. What regarding today's bond hearing, what brings you to court for today's bond hearing?
Because May the 23rd, Ms. Brooks allowed her niece and her daughter to try and set my house on fire.
Okay, and how did Ms. Brooks allow her niece and her daughter to set your house on fire?
Because they were doing it right in front of her.
Okay, so let's go back just a little bit, Ms. Watkins. How did you come to know that Ms. Brooks' niece and daughter were trying to set your house on fire?
Because on May the 22nd, I called the police because they were trying to knock my security camera off of my house.
Pause. Can the individual on the iPhone please unmute and tell the court your name?
Ahmed Baker. Ahmed Baker.
Okay, hold on. You're saying Baker?
Yes, B-A-K-R.
Isn't this a defendant from another day?
Yes.
Well, why is he here? Sir, why are you here?
I've had court today. I was told to come back see you come back on the 21st at 1:26.
Can you look him up, Mr. Baker? All right, give us a moment.
Okay.
Spell your first name.
T-H-A-M-E-D.
Last name, B-A-K-R.
Yes, ma'am.
All right, give us a moment, sir.
Okay.
All right, Ms. River.
Thank you, Judge. Ms. Watkins, I believe the last thing you said was they were trying to knock the cameras off of your home.
Yes, they were trying to knock my security cameras off my house.
And who are they?
Ms. Brooks, Lauren Smith, and India Green.
Okay.
One moment. Mr. Baker, you're a month early, sir. You can unmute. You're a month early. You're supposed to come on September 21st.
September 21st. I apologize.
That's okay. Have a great afternoon. Stay safe.
Likewise.
All right, I'm gonna bring you to jail. Can the jail start the video? For Mathis, please. All right, can they unmute Ms. Mathis? Okay, thank you. This is case number, 234461601, the people of the state of Michigan versus, is it Demetrius or Dimitri?
Susan.
Oh, I don't see it, okay. Where? Oh, it's a different map. Okay, did y'all see these two mattresses on my document? Yeah. Okay. Strike that then. This is case number 234461001, the people of the state of Michigan versus Susan Kimberly Mathis. The defendant is charged with one count of assault or assault battery. Today is the day set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the record, Your Honor, Janet Stevenson appearing on behalf of Ms. Susan Mathis. Good afternoon, Ms. Mathis. Ma'am, please say your full name.
My name is good afternoon. Good afternoon, Your Honor. My name is Susan Kimberly Mathis.
Today is the day set for pretrial conference Ms. Stevenson?
Your Honor, we move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Judges, at least the second scheduling of the pretrial conference, the court required the complainant witness, Gerald, to be present. I don't see Mr. Fitzgerald in the waiting room, Judge, and I don't believe he's here in person. At this time, Your Honor, the people have no explanation as to why the complainant witness is not present, and we will not be able to move forward based on the complainant witness's failure to appear for at least the second scheduling of today's pretrial conference.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear. People have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Ms. Mathis, we will send over your paperwork, with respect to this case. If this is the only matter you're being held on, then you should be released. If not, then you have to take care of your other matters, okay?
Yes, ma'am.
All right, have a great day, stay
Thank you
safe.
so much. Thank you.
Thank you.
Thank you, Ms. Stevenson.
Welcome, Ms. Susan Mathis.
Am I done?
Yes, ma'am.
Yes, ma'am. You enjoy the rest of your evening.
Thank you. I hope she don't have nothing else, cause she's so excited.
I don't think she.
Oh, she was being held on this?
Well, she had a tether.
Oh, okay.
Yeah.
All right, oh, cause I know, she's so excited. Okay, Ms. Ritter.
So, Ms. Watkins, going back to your answer, you said they were trying to knock your camera down. Can you repeat who they are again?
Yes, Ms. Brooks, India Green, and Lauren Smith.
And just for court purposes, how do you know Ms. Brooks?
She's my next door neighbor.
Okay, and do you know Ms. Green?
I believe that's her niece,
And who's the other person?
her daughter, Lauren Smith.
Okay, and, does Ms. Green and Ms. Smith live next door to you as well?
Lauren Smith does. I don't know if, India Green resides there.
Okay, so you said they were trying to knock your cameras down, and what did you do after you found that information out?
Well, I called to make a police report, and the lady at the police station told me to check my cameras the next morning, because it was in the evening, to see if any damage was done. So the next morning, as I checking my cameras, that's when I seen them trying to pour the gasoline on my fence. I immediately called the police. They sent out an arson investigator to scrape up samples, and they found a water bottle that has gasoline in it.
Okay, so let's just go back just a little bit, Ms. Watkins. So what day did you contact the police?
The first day was May the 22nd.
And what happened when you contacted them after that?
That's when the lady told me to look at my cameras. She actually told me to call back if my cameras was damaged and use the same report number. But when I viewed my cameras the very next day, which was the 23rd, but it says on the camera, the footage it all happened May the 22nd. So when I contacted, they sent the police. When I contacted police, Detective Forte actually wrote up a warrant for the 14-year-old girl that was seen in the video.
Okay, so you looked on your cameras and discovered that they were,
Yes,
I'm sorry, you looked on the cameras and discovered that Ms. Brooks, Ms. Green, and Ms. Smith were the individuals that were spraying the content on your fence?
well, India Green and Lauren Smith was spraying the content. Ms. Brooks was sitting on the porch having a conversation with them, and then she walked right past the young lady when she came out with a bucket, because she came out with a bucket when the spray gun was empty. She came out with a bucket, and
Who's she?
India Green.
Okay,
And Ms. Brooks was standing, she walked right past her when she was doing so.
okay, so Ms. Brooks wasn't the actual person who sprayed the gasoline?
No, it was her daughter,
Okay.
Lauren Smith, and her niece, India Green.
Okay, and you're testifying to the court that Ms. Brooks was present while this was being.
Yes, she was.
Okay, so when you obtained that information, what did you do next?
Well, after I called the police, Detective Forte, contacted me. I had to go in and sign, a statement for them to issue a warrant out for India Green.
Okay, and what did you do with the footage when you, viewed the footage and saw that this individual was saying this content on your page?
Well, Miss Forte got a copy, and then I sent a copy to the prosecutor, Mr. Ricardo Moore, I think that's his name.
So you spoke to Mr. Moore?
Yes,
Okay,
and he told me that he would present the, evidence to the courtroom.
okay. And did you, turn over the video to Mr. Moore?
Yes, I did.
Okay. Judge, may I? You may share my screen, I'm sorry.
Sure.
Okay.
You like, I ain't doing it. It's somebody else.
Right.
It should be hanging in my closet.
Okay.
Yeah, please.
You may.
Thank you. So, Miss Watkins, if you're looking at the court monitor inside the courtroom, do you recognize what's on the court monitor?
Yes, I do.
What do you recognize that to be?
That's my front porch, and that's my fence, and on the other side, that's, Lawrence Smith, Mr. Brooks' daughter's car, and that's her side of the driveway. And as you can see India Green standing right there at the fence.
Okay, hold on, Ms. Watkins.
Okay.
I'm just asking you, would you recognize this footage?
Yes,
You recognize this footage?
yes, I do.
And is this the same footage that you turned over to Detective Forte and to the prosecutor?
Yes, that is the footage from my security cameras on my front porch.
Okay, Judge, at this time, if people like to admit people's proposed exhibit one into evidence.
Any objection?
No objection, Your Honor.
People's proposed exhibit one is admitted as people's exhibit one.
Thank you, Judge. At this time, people like to publish people's exhibit one to court.
Okay.
Thank you, Judge. And for the record, I'm playing the video camera footage at 1 minute and 15 seconds. People are stopping the video at 1 minute and 49 seconds. So Ms. Watkins, looking at the screen, do you know who those two individuals are?
Yes, that's India Green in the white t-shirt, and that's Lawrence Smith in the gray sweater.
Okay. For the record, Judge, people are playing the video at 1 minute and 49 seconds. At this time, the people are stopping the video at 3 minutes and 5 seconds. So Ms. Watkins, looking at the screen, do you see the person that's standing on the porch?
Yes, I do.
Do you recognize who that person is?
Yes, I do.
Who do you recognize that person?
That's Miss Bonita Brooks.
Okay, can you describe what she's wearing?
She has on a gray body, a black t-shirt, and pink pajama pants.
Okay. Judge, for the record, the people are playing the video again at 3 minutes and 5 seconds.
You see them in this video?
Yes. This time, people stop the video at 5 minutes and 1 second. So, Ms. Watkins, you indicated to the court, you testified that this is the same footage that you turned over to the detective, correct?
Yes,
And what date did this incident occur again?
it happened May the 22nd.
Okay, and was there any other, contact by Ms. Brooks after this date?
Yes, April the 5th. I'm sorry, August the 5th.
And what happened on August the 5th, Ms. Watkins?
She put in my husband got.
Hold on, ma'am.
Objection. Your Honor, it was my understanding that we want to be as prepared as we possibly can be for today's hearing. It's my understanding that the reason we're having today's hearing is to investigate the complaining witness's contention that somebody poured, that my client poured gasoline on her fence. So at this point, we're here with evidence supporting that somebody else may or may not have been pouring gasoline on the complainant's fence. And now we're also here talking about allegations of cameras being damaged. And now we're also being here talking about allegations of something that's happened separately. And I just think that we've gotten far afield with what the initial allegation was. And this, we're only here prepared to answer to the allegation that my client allegedly having poured something on the complainant, gasoline in particular, in the complaint.
Ms. Ritter, do you have a response?
You objection? I'm sorry.
Do you have a response to the objection?
No, Judge, the people will move on.
Well, I don't know that people need to move on. So I disagree with you, Ms. Stevenson.
Yes, sure.
Today is the day set for a bond hearing. And I believe at the time that I set the bond hearing, I did focus on the gasoline being poured. However, if there is any proof of any violation, hold on, of my order, I want to hear about it. If I got more money, I can do it. If I got enough money, I can do it. On the table. Yes. Thank you. No, I mean, it's Flanagan went downstairs getting snack because I'm hungry and I have a headache and I didn't get to eat lunch. So the objection is overruled. Actually. As long as Mr. Stevenson became aware of it before now, like before this very moment. When did you let her know about this August 5th allegation?
This, if the people believe this August 5th allegation is what the evidence that we had, this was sent over with the reports of the gasoline being poured, the police reports of gasoline being poured. So what was submitted to the people were the report and some screenshots. If I think this is what she's gonna produce, some screenshots, some social media posts that were directed to us.
Oh yeah, I remember them talking about social media posts on that first day, Ms. Stevenson. And then I got focused on the gasoline.
If that's what, I don't know the exact.
Well, let's see, I'm good at not considering something. So right now the objection is overruled. You can see what she's talking about.
Okay, so can I just be clear that the
Yeah.
responses that I knew about whatever it is that's gonna be coming before right now, that's. Is that what you asked?
Oh, yes, ma'am. Yes, ma'am.
Okay.
Right.
I guess-
If it's not if this isn't a surprise in terms of, let's hear what she's gonna say. If you tell me you didn't know anything about this, then I can reconsider my objection, my ruling. So go ahead and let me hear what she's gonna say.
Okay, so Ms. Watkins, as you were saying, you mentioned August 5th date.
Yes, August the 5th, my husband gets a call from his brother. So Ms. Brooks, again, posted, he's on the sex offender list and it was posted on a Green Bell app. So my husband didn't say anything about it. We left it alone. Then that Sunday, which is August the 7th, she posted it on her Facebook page with my name on it,
Okay, and when you say she, who are you?
Miss Bonita Brooks.
Okay, and what exactly was posted regarding?
She put my, husband's sexual offender, information and put my name on it. She said that, Gwendolyn Watkins and her husband's been harassing me for 6 years and DPD need to do their job. I sent the post in.
Okay, so Ms. Watkins, just to back up a little bit, so Ms. Brooks posted this to where?
On her Facebook,
Okay, and did you see the post for yourself?
yes.
Okay, and what did you do when you saw the post?
I took a picture of it and I made a police report.
Okay, and do you have the police report now?
Yes, ma'am.
Okay, I don't know, the people should continue to.
Continue unless I tell you to stop.
Okay, so, right at this time, if people would like to try to admit evidence, but due to the personal information that's being allowed.
Okay, thank you. Don't share it on the screen, just, present it to me.
Okay.
Any objection from defense? These be costing $2 by themselves. Any objection?
No, thank you, Your Honor.
All right, it's admitted, and you can publish it to me.
Thank you, Judge. Now,
Why don't you just send it to, can you send it to me on the email?
I can do it. Oh, reports email or?
Yeah, of course, you know.
Okay,
Forward to me.
and Ms. Watkins, after you submitted that report, or I'm sorry, after you submitted that information to Lynise, you made a report, correct?
Yes, I did.
Okay, and what did you do after that?
I did nothing. I just received a letter from Pamela Smith at the 8th precinct. I'm waiting for her to set me up an appointment to come in. I just received a letter yesterday.
Cross-examination.
Good afternoon, Ms. Watkins.
Good afternoon.
So how were you able to see Ms. Brooks' Facebook post, the one that you sent to the police?
A neighbor sent it to me.
Okay, and, and you considered that to be, an act of harassment?
Yes, ma'am. This is not our first time doing
Okay, why did you consider this particular post to be an act of harassment?
it. Because she posted my name with it.
Okay, all right. Okay, so, on May 22nd, you and Ms. Brooks live next door to each other?
Yes, ma'am.
Like right next door? to each
Yes,
other?
ma'am.
And how long have you lived directly next door to each other?
I've lived there since 2017.
How long have you lived directly next door to each other?
5 years.
Okay, and, how many times would you say the police have been out? Because either you called them or Ms. Brooks called them.
Well over 20 times.
Your
Yeah.
person is just out of this.
So, on May 22nd, you called the police to your house?
I called the police to report them, trying to knock my camera off my house.
Okay, and you said that you were directed to take a look at your cameras, correct?
Yes, I wasn't able to look at them until the very next day because it was dark.
Okay, did you tell the police whether you had any
Yes.
damage to the cameras?
I didn't have damage to my camera, but that's when I found the video.
All right, got you. Okay, so you said that you believed that somebody was damaging your cameras?
Yes, I have proof of it.
What kind of proof do you have that they
You
were
can see
damaging?
them trying to knock my
Hold on,
camera.
ma'am, hold on. Let her completely finish her question so that I can make sure I know what question you're answering. Ms. Stevenson, what was your question?
So you said you have proof that somebody damaged your cameras.
Yes, ma'am.
Okay, and so what is the proof that you have the damage to the camera?
I have video.
You have videos of the damage to the camera.
Yes, ma'am.
Okay, and you gave that to the police as well?
Yes, I did.
Okay, all right, so, the incident that brings us here to the substance on the fence and all that happens on May 22nd?
Yes, it does.
Okay, so did the police come to that? Do you know whether or not the police came to your house, sometime before immediately before this incident with the substance on the fences?
No, they came to my house the day that that we viewed the footage. The day that we viewed the footage was 23rd.
Okay.
It happened on the 22nd.
Okay, all right. So the police, the stuff goes on the fence on the 22nd,
Yes, ma'am.
and then the police came over on the 23rd.
Yes.
Okay, all right. So did the fire department also come out?
Yes, the arson investigator was sent to my home.
They came out on the 23rd.
Yes, ma'am.
Okay. Did you see anybody with any gas cans or anything like that up against your fence?
I don't know what they had.
Okay,
All I seen them do was
No,
spray
ma'am,
my
the
face.
question is, did you see anyone with a gas can?
No, not with the gas can.
okay. So you saw them, you didn't see this when it was happening, right?
No.
Okay, you saw somebody using some kind of a device to pour something onto your fence, right?
Yes, first they sprayed.
Okay, hold on a
Ma'am,
second.
just answer the question.
So what were they using to put something on your fence?
The first time they used it looked like a water gun.
Okay, all right, and so that was the video footage that you gave to the police?
Yes,
Okay, and so you see somebody kind of spraying the fence with a water gun, right?
yes,
Okay, and then you see somebody kind of swinging the water gun around, correct?
yes.
Okay, all right, and so, and how much time do you think passed between that happening and when the police came out to investigate?
With the video was, I watched the video the very next day. So it took about, I wouldn't even say about maybe 20, 30 minutes for them to get there.
Okay, and did you tell the police that it smelled like gas or?
They picked up a plastic bottle from my yard that
Okay,
had gasoline in it. Because she used the bucket.
Please just answer the question.
She,
Ms. Stevenson, next question.
well, okay, do you believe that somebody used a bucket to put gas on your fence?
yes,
Okay, so somebody you believe had a bucket of gasoline and threw it on your fence.
yes,
Okay, and that's the fence that's directly between it's your fence, right?
yes,
Okay, but it's a fence that's right at Ms. Brooks' property as well, right?
yes, her property sits on the other side.
Okay, all right, so, so have you and Ms. Brooks been good neighbors?
No,
Okay, there's been conflict between the two of you?
Judge objection.
yeah, she went over my house.
Please, when there's an objection, please stop speaking.
Ms. Ritter, relevant to.
Ms. Stevenson.
Your Honor, the rules of evidence are absolutely relaxed in a bond violation hearing.
I know, but you know, I only wanna hear about relevant stuff, so is it relevant to whether or not your client violated my bond?
Is it relevant? Yes, because I believe it goes directly to this witness's credibility, Your Honor. If there's a lot of animosity between these parties, and if they lived next door to each other for 5 years with problems going back and forth, I believe that that's absolutely relevant. I think the court will want to, the finder of fact would want to know.
I'm not the finder of fact, you're talking about at the
In terms of
bond.
the bond violation.
The objection is sustained.
Thank you. So do you have any reports with you from the police department indicating that the substance that you believe, the liquid that you believe is gasoline?
Yes,
Okay. Do you have
Ms.
that?
Ritter has it.
Okay. Can I see that, please? So the police report that was made based upon your representation, correct?
The police sent an arson investigator.
Ma'am, please listen to the question.
Okay, and then the police report says that the bottle smelled like gasoline, correct?
Yes,
Okay, did you tell them it smelled like gasoline?
no,
Okay, but a police officer said it smelled like gasoline.
yes,
Okay, all right. So it was, from the video footage that you brought in with you today, when Ms. Brooks, it's actually not Ms. Brooks that's putting anything on your fence, correct?
no,
Okay, and is that what you told the court last week, that Ms. Brooks was putting gas on your fence?
no, I told them exactly what was made in my report.
Okay, did you tell them that Ms. Brooks was standing around watching while that was happening?
Yes,
Okay, and in the video that you supplied to the court, Ms. Brooks actually comes out of her house after somebody else is spraying the fence, right?
yes,
And did she walk directly over to the fence?
yes, she did.
She didn't sit down on her front porch?
She, in the first video Ms. Ritter showed, it shows that she's sitting on her front porch.
Okay,
She
And then
has
she-
other videos.
all right, so Ms. Brooks comes out of the house and the kids are in the yard with the water guns, correct?
Yes,
And then Ms. Brooks sits down on her front porch, correct?
yes,
Okay, all right. Okay, I don't have anything further here.
Ms. Ritter. Ms. Watkins, you viewed the video that was played for, correct?
yes, that's the video footage from my camera, but I also sent video footage from the lady, Miss Triplet, across the street. Her driveway sits directly across from your driveway, and I sent you footage from her cameras as well.
Okay. And did you submit those additional, camera footages from your neighbor across the street to the police as well?
Yes,
Okay, Judge, may I share my screen? Ms. Watkins, are you looking at the monitor in the courtroom?
yes,
Do you recognize what's up on the screen?
yes.
What do you recognize that to be?
That is Miss, Bonita Brooks' driveway.
Okay, and is this the same, footage that you sent to the police?
Yes, it is.
And where's this footage from?
That is from Miss Triplet's house. She lives directly across the street.
Judge, at this time, people would like to limit people's proposal to.
No objection, Your Honor.
Exhibit 2 is amended.
Thank you, Your Honor. At this time, people would like to propose to support. Okay, thank you. Okay, so Ms. Watkins, were there any other, camera footages submitted to the police regarding this incident on May 22nd?
Yes,
I thought it was publishing exhibit 2. That was all of it?
they're short.
Oh,
videos.
ma'am. Okay, well, I was waiting on it. Show me that again. I wanna look at, I mean, I looked, but I thought it was gonna be some more. Mhm.
Oh, okay. And, you may, and Ms. Watkins, do you recall how many videos from your neighbor's camera you submitted to the police?
I submitted 3 of them.
Okay. Your Honor, ma'am?
You may. Play it again. And I apologize. All 3 of these videos were supposed to be exhibit 2.
And Ms. Watkins, my last question is, again, was there additional footage from your house regarding this incident that took place on the 22nd?
Yes, it was from my back view.
Okay, and did you submit that video to the police department?
Yes, I did.
And did you also submit that video to the prosecutor's office?
Yes, I did.
Ma'am, you may. Put my screen share.
You did. I didn't touch it.
So Ms. Watkins, looking at the screen in the courtroom, do you recognize what that is on the screen?
Yes, I do.
What do you recognize that to be?
That's the side of my home that sits on Bonita's, side from her driveway.
And is this the same footage that you submitted to the police department?
Yes, it is.
And it's the same footage that you submitted to the prosecutor's office.
Yes, I did.
Judge, at this time, people like to submit people to exhibit 3 into evidence.
It's a minute.
Judge, at this time, the people would like to publish.
I apologize.
No objection.
Okay, thank you. Now it's admitted.
Thank you, Judge. At this time, the people would like to publish exhibit 3 into.
You
to the
may.
court, I'm sorry.
You may.
Thank you. And for the record, Judge, the people are playing a video at 14 seconds.
Oh.
But at this time, the people stop to be at 5 minutes and 6 seconds. And last question, Ms. Watkins. Regarding the incident, with the gas on the fence and the Facebook post about your husband, did you, I don't remember if you testified, did you submit that information to the police?
Yes, I did.
And did you file a report regarding those two?
Yes, I did.
Judge Mayor?
You may.
Judge Mayor, approach.
Yes.
Ms. Watkins, I just handed you 2 documents. Once you're done reviewing those 2 documents, just look at them.
Oh, 1 second, I apologize. I mean, she can review the documents, but before she speaks, I'm gonna address. All right, good afternoon. Ms. Peterson, was the Dennis case the only case that you all were here for?
Yes, Your Honor.
All right, well, it's 2:31 and Mr. Dennis has not appeared. So Mr. Flanagan said that he is not caseous before. So I'm gonna be adjourning his case. What day? Oh, I don't, what day was that? I think I'm gonna adjourn it to. Was I giving out? Did I adjourn till October 9th this morning?
This morning, no, but on Friday you were using October 6th.
Okay, yes, I'm going to adjourn the case to October 9th at 8:35, so it'll be in the morning.
Okay. Thank you.
All right, okay, you're welcome.
Have a good one.
Stay safe.
Bye.
All right, Ms. Ritter.
Thank you, Judge. So, Ms. Watkins, did you have an opportunity to review those 2 documents that I handed you?
Yes,
And looking at those documents, one is labeled, Exhibit 4. Do you recognize what that document is?
yes, ma'am.
What do you recognize that to be?
This is the, May 22nd.
Okay, and if you recognize that document, to be altered or changed in any way?
No,
Okay, and is that the police report that you received from the police department regarding that incident?
yes,
Okay, and there's another document listed as Exhibit 5. You see that document?
yes,
Do you recognize what that document is?
yes.
And what do you recognize it to?
A report that I made for August the 7th.
Okay, and is that the police report that was submitted to the police department?
Yes,
Okay, and has that document been changed or altered in any way?
no,
Okay, then at this time, the people will move to the people's proposed Exhibit 4, 5 into evidence. Any objection?
I'm gonna object to the police reports, Your Honor. I think that the police officers who actually generated those reports need to be here. I think that that's hearsay.
It is
Yes.
hearsay, it is hearsay, but it's an evidentiary hearing. It's hearsay, it's hearsay.
So I don't have an objection to the witness testifying that she made a report to the police department. But for the witness to testify that the report that she has in her hand, that the police is what the police put together, I think is inappropriate. I don't think that's
Do
appropriate.
you have a response, Ms. Ritter?
Judge, the police reports that were handed to Ms. Watkins, she recognized those to be the police reports that she made for those incidents. So I believe that the witness laid a proper foundation as to what those documents were. As far as the police reports, although it's hearsay, that was the information that was given to the police.
So she can, I don't have an objection to her testifying as to what she told the police. But as to whether or not that's the report that they put together, I don't think there's a proper foundation.
Well, I disagree with you, Ms. Dixon, however, we're currently trying to find a rule for its evidentiary hearings, because I believe that, not evidentiary hearing, but a bond hearing, hearsay is admissible. In a bond hearing, hearsay is admissible, so it wouldn't matter, the police don't have to come and testify. I can receive hearsay, so I'm gonna overrule the objection unless I find something, some that can be shown to me otherwise with respect to receiving hearsay at a bond hearing, but I believe hearsay is admissible. You may proceed.
Thank you, Judge. Judge, is this, I'm sorry, I'm sorry, the court rule is.
Or do you, because her objection was to the commission. Oh, the objection is overruled, and then, people's exhibits 4 and 5 are admitted.
Thank you, Judge. At this time, people like to publish people's exhibit 4 and 5. I'm sorry, publish people's exhibit 4 and 5 to the court.
I'm gonna say you may, but I'm gonna hold, she can hold on to.
Okay, Ms. Watson, if you don't mind just putting those documents face down right, thank you. At this time, Judge, you have no further questions for me.
Okay, Ms. Dixon?
So on there's a video that you submitted with Ms. Watkins that looks like it's from somebody's backyard, correct?
It's from their driveway.
From the driveway. Okay, and in that video, you see somebody who has a bucket of some liquid, correct?
Yes.
Okay, did you see what that individual did with that bucket after they dumped the water?
They jumped it on the ground.
Okay, near a car?
Yes.
In their driveway, okay, all right, and then, so the Facebook posts that are referenced in the police report. You referenced Facebook posts in the police report, correct?
Yes.
Okay, and somebody else showed that post to you
Yes, it was sent to my phone.
by somebody else?
Yes.
Okay, somebody other than Ms. Brooks?
Yes.
Okay, all right, let me bring it up.
Play the exhibit 1 for me again. The young lady that I see in the video that's doing something at that fence, who do you believe that to be?
With the white shirt on,
Not you testing my knowledge. Whoever, back it up just a little bit. Enough so we can see that. That young lady right there with that red,
that's India Green.
and who is that person to, Miss Brooks?
She told the police it was her niece.
And the person in the dark colors, who do you believe?
That's her daughter, Lauren Smith.
Okay, play the video for me again.
At this point,
Yes, just right.
I think so.
To your knowledge, pause, I apologize. To your knowledge, the young lady that you believe to be Miss Brooks' niece, to your knowledge, is she under the age of 18?
Yes, ma'am.
Why do you think that?
The police told me that she was 14 years old. Detective Forte.
Play for me again.
at this point,
Yes. I want to see when Miss Brooks, the person that the witness has identified as Miss Brooks, I want to see when she stands up off the porch. That's what I want to see. I'm gonna see that in this video, right?
yes.
While I'm waiting to see that, ma'am, does your video camera have sound?
My camera from my front porch is, no, it doesn't.
Okay.
It doesn't.
All right, you can stop it. Are there any questions based on the questions that I asked the witness?
Briefly, Judge. So Ms. Watkins, the person that you're identifying as India Green, do you know that person to be a household member of Ms. Brooks' household?
No, she's not.
Okay, and well, let me better ask this. Have you seen her prior to this incident on May 22nd? Have you seen the person you're calling this India Green?
I apologize, I had another question. So let me ask the question in case you have some questions based on my question. I just had a question, I'm sorry. What date were you given that Facebook post? What,
Sunday, May the 7th. I'm sorry, August the 7th.
So you got the Facebook post from your neighbor August the 7th?
Yes, ma'am, it was sent to my phone.
Okay, that's all, I forgot, and I, just in case you had a question. Okay,
May I proceed?
you may.
Thank you. So have you seen this person you're identifying as India Green prior to the May 22nd, 2023 incident?
Yes, I have.
You see her frequently at Ms. Green or Ms. Brooks' house? I'm sorry.
No.
Okay. No further questions.
Ms. Dixon, any questions?
No, thank you.
Thank you, ma'am, you may step down off the witness stand. Any further questions on behalf of the, people? Any further? Any further witnesses on behalf of the people?
No, Your Honor.
All right. Anything on behalf of the defense at this time?
No, thank you, Your Honor.
All right.
I know for next time, watch it.
All right. Ms. Ritter, did you want to bring anything specifically to the court? Oh, I will receive the exhibit, the two exhibits. 4 and 5. You may. All right, did you want to bring anything specifically to the court's attention with respect to this hearing?
Yes, Judge, and the people don't mean to treat it as a trial. at this point.
No, don't worry.
But just to summarize the information that the court received this afternoon, the people just want to point out the specifics in the videos, Judge. As the court has used the 5 videos that were submitted to the court today. In one of the videos, Judge, you could see these 2 individuals spraying some type of content from a water gun and dumping something out of the bucket onto the dispensary. And I know this court has a keen eye for detail, but in the video, you can see these 2 individuals moving away and their actions are as if they're not trying to get this content on themselves. So which leads the people to believe, Judge, that what Ms. Watkins presented and testified to the court that the content on her fence was the gasoline. Additionally, Judge, as the court viewed the video again, one of the cameras showed Ms. Brooks sitting on her porch, or who Ms. Watkins believed was Ms. Brooks sitting on the porch. And while these 2 individuals were spraying this content on the fence, Ms. Brooks was present during a period of time where the content was being sprayed on the fence, Judge, and didn't say anything, which means, or which indicates to the people that she condoned the actions that were being taken place by these 2 individuals, Judge. So I just want the court to recognize that the videos of the gasoline being put on the fence and the videos from the Facebook post, or I'm sorry, the screenshots from the Facebook post that were submitted to the court, definitely poses a safety risk, Judge, including the violation of the court's no contact order. But more importantly, it poses a safety risk to Ms. Watkins and her family, Judge. And the people just want the court to take that into consideration because this is just a misdemeanor. I believe that the actions being taken place are unnecessary, it's unacceptable, and it, like I said, it poses a safety risk outside of violating the court's no contact order. So I just want the court to receive that, Judge, and again, revoke Ms. Brooks' bond while this case is pending.
Thank you, Your Honor. So, the Facebook post itself, I don't know, it is a stretch, I would argue, to say that that is a violation of the court's no contact order. Certainly, if it were to be shown that Ms. Brooks made that post, and I'm not conceding that, there's nothing to show that that was sent directly to Ms. Watkins, and Ms. Watkins never would have even seen it had a third party not intervened. So we don't believe that there has been a showing of proof beyond the preponderance of the evidence that the no contact condition was violated by that Facebook post, Your Honor. With regard to the issue, I think that really brings us to court. So the people's representation was that my client was pouring gasoline on the complaining witness's fence in violation of this court's no contact order. So just looking over the video, I didn't see any liquid handled in a way which would suggest to me that that was gasoline. Certainly there's some liquid, but I don't know about gasoline coming out of water guns. I don't know about gasoline being carried around in some kind of a bucket. I don't know about a water gun containing gasoline being kind of swung around and all that other kind of stuff. I don't know about gasoline in a bucket being poured out and then the bucket being discarded right there in the driveway near the car on the defendant's property, Your Honor. I don't know about a fence being doused with gasoline, a fence that is absolutely adjacent to the defendant's property is being gasoline. Now, So just kind of getting to it. Looking at the video, my client comes out of the house and she has a seat down on the porch. And the kids are over there doing whatever it is that they're doing. Now, would it have been wise in hindsight for Ms. Brooks to say, look, there's stuff going on between us and Ms. Watkins, you guys get over here and stay away from over there? I think that absolutely would have been wise. But does this action or inaction on Ms. Brooks' part rise to the level of condoning, of giving direct, of giving tacit consent to whatever they're doing? I disagree with that vehemently. I don't believe that there's way more going on here. And I guess that's gonna be part of the purpose of the trial. There's way more going on here between these two people who live within shouting distance of each other. Within, they don't even have to talk loud to come into contact with each other. And they've lived next door to each other for 5 years and they're just not getting along. And I think that there's stuff going both ways. I believe that that's definitely gonna come to light as we move forward with this case. Ms. Brooks understands that it's been the order of this court that she have no contact. It's been the order of another court that she have no contact with Ms. Watkins. I don't believe the people have presented proof beyond a reasonable, by the preponderance of the evidence that Ms. Brooks has directly or even tacitly violated the court's no contact condition. I'm asking for the bond to remain intact. Ms. Brooks is not reaching out to Ms. Watkins. She's trying to keep her distance from Ms. Watkins, even though they were so close to each other. And I don't believe the court has been given enough proof beyond the preponderance of the evidence that Ms. Brooks is initiating contact with Ms. Watkins in violation of this court.
Ms. Ritter, anything further? Judge, again, I'm just asking for to take into consideration the evidence that was submitted by the people. Looking at the police reports, I believe they corroborate exactly what Ms. Watkins testified to this court today. And again, it's not just a violation of the no contact order at this point. It's definitely a safety risk to Ms. Watkins and her family members regarding this case. So we look at for the safety just into consideration of today's conference.
Everybody knows how I feel about neighbors getting along. I shouldn't say everybody, but in council, you all know how I feel about neighbors getting along. So here's the issue. Issue is whether or not people have presented enough proof by preponderance of evidence for the court to determine that Ms. Brooks has violated the conditions of her bond, which is to have absolutely no contact of any kind with Ms. Not regular complaint. Y'all start doing these new complaints. Okay, with Ms. Watkins. I gotta find her victim name, complainant's name. With Ms. Watkins, she was to have no contact of any kind with Ms. Gwendolyn Watkins by any means, directly or indirectly, on her own or with someone on her behalf. I'm gonna address the Facebook post first. I was presented with a Facebook post and I was presented with a complaint, a police report regarding the Facebook post. What I'm gonna say about the Facebook post is this. I disagree with Ms. Stevenson that it was not, that Ms. Watkins wouldn't have been able to see the Facebook post, but for her neighbor showing it to her, because I'm looking at the Facebook post and it is public. It's not just relegated to her friends on Facebook. So I could go to this Facebook post and if it's still up, I would be able to see it, not being a friend of Ms. Brooks or Ms. Watkins was just on Facebook, or she looked, looked her name up, or I don't know when the public, some posts that pop up on Facebook feed that are public, but I can say that she would be able to see it. The problem I have with the Facebook post is this. Notwithstanding the fact that her neighbor turned it over to her and she reported it on August the 7th, there's no date on the Facebook post. So I don't know what date the Facebook post was actually posted. If it was posted after the court's order, it would be a violation. Without having the proof of when it was posted, because there's no date on the Facebook post itself, then with respect to the Facebook post, the court does not find a violation. Now, is it distasteful, petty, ridiculous, dumb, and everything else? It is. Is it childish? Is it a reason that somebody now would come out on the defensive? It is. Is it something that if she got the wrong person, they wouldn't take it kindly and they might do something towards her because of it? It is. She needs to grow up. With respect to the Facebook post. With respect to the videos. I was shown several videos, and basically the videos showed some kids spraying something on Miss Watkins' fence. Looking at the fence, it appears that the fence is on Miss Watkins' property line. And the fence, Ms. Watkins testified that it's her fence. It is her fence. And generally speaking, when the side where the posts are, that's the owner of the fence, the side where the posts are. So the court believes that the fence at issue belongs to Ms. Watkins on her property. So what the video shows is two bad kids spraying something on her fence. The report from the report regarding the arson report indicates that, of course, no arson had taken place. No one actually burned the fence, and then they, were shown a bottle that smelled like gasoline, and then the camera footage, they said it was too blurry for them to determine anything about that, but they did, of course, see, I guess, what we saw, which was the something being put on the fence. At a certain point in the video, after the two bad kids have been putting something on this fence, an individual identified by the witness as Bonita Brooks comes off out of the door, out of the house, and they come onto the porch. When they come onto the porch, the person who has been identified as a 14-year-old niece of the defendant, Ms. Brooks, continues to spray something on the porch. They continue to, on the fence. They continue to put something on the fence. The individual identified as Ms. Brooks has come out onto the porch, and then she sits in a chair. She has a computer in her hand. And then for at least another minute, the person that is identified as her 14-year-old niece is putting something on the neighbor's fence. At no time do I see Ms. Brooks motion to the person to tell them to stop. At no time do I see any interaction between Ms. Brooks and this individual. Ms. Brooks then, at a certain point, casually walked off her porch. And then everybody go to the back. Now, from the other video that I saw, when they get to the back, they're still putting something on the neighbor's fence. So from the other video, when the two young ladies come to the back, they're still pouring something on this neighbor's fence. I suppose they went in the house, I don't know. At a certain point, I see the doors open, the side door open. And then I guess some people go in. For the minute and or so that 14-year-old person was spraying something on the fence, and Ms. Brooks sat in her chair and didn't say anything to that person, she acquiesced to the person spraying something on Ms. Watkins' fence. She agreed. She was not merely present. Why do I say she was not merely present? Because she had an order to have no direct or indirect contact with Ms. Watkins. She allowed a minor child to continue to put something on Ms. Watkins' fence. Have the people shown me by a preponderance of the evidence that it was gasoline? No, they have not. I don't care if it was Kool-Aid. I don't care if it was water. Ms. Brooks sat on her porch and watched an individual that was visiting or living, whichever the case may be, her household, spray something on the neighbor's fence, and she didn't say anything. And that's why kids out here bad and need their tail whipped. Because their guardians and the people who have control over them are setting poor examples. Now let me say this. I don't care what's going on with the neighbors, right? It's clear that at the time that this is occurring, Ms. Watkins is not either at home or present outside. If Ms. Watkins had just cursed them all out and then went back inside her house, it is a violation of the court's no contact order for Ms. Brooks to allow her kids to now go and try to damage the lady's fence. I say time after time after time, I don't know what I would do if I had a bad neighbor. I just don't know what I would do. Because I've never had to experience a bad neighbor. Because me and all my neighbors must have common sense. Now, I got one neighbor right now that's on the back part of my house that's not the friendliest people. And so therefore, I just try to wave my hand and that's it. So I don't know about all of this right here. But if I see the neighbor's kids trying to damage my fence and the neighbor sitting right there on the porch, it's gonna be me and the neighbor. We're gonna have a disagreement. We're gonna have a situation. We're gonna have a conversation about why you letting your bad kids do something to my fence. Now, I don't believe, or I know that she wasn't outside at the first part. That's why I want to see the video. Cause I thought I saw her come outside when somebody was still doing something to that fence, and I did. And she did. And I'm finding that that is a violation of the court's no contact provision. Now, what's the penalty for that? I don't agree that it should be the revocation of her bond. Ms. Flanagan, tell me what her bond is. Can you look it up?
$5,000 personal.
And it was never a GPS.
No.
And then one thing that saved her was that truck, that white truck. I don't know who white truck that was, but it was blocking the neighbor's camera. So that's one thing that's saving her from having her bond completely revoked, because I couldn't see what happened when they went in the back. But if that white truck hadn't been there, and I could see exactly what happened when they went in the back on the side of the house, she probably was gonna get her bond revoked. You said no, never was?
No, just may not own, possess a firearm or any other weapon.
Here's the problem I have. I'm not, you all know, I'm not gonna keep somebody in, what is this scheduled for next?
That's final control. October.
Final pre-trial schedule at what time?
9/18.
Oh, 9/19, so it's trial date. Here's the problem I have, here's the dilemma I'm in, I'm gonna tell you. I don't, I don't believe in putting somebody, in jail on a misdemeanor. That's gonna exceed the punishable amount. She's charged with a ag or regular, no. It's malicious destruction of property. Oh, yeah, this A and B, and then this was just the situation with, okay. So that's a 93-day misdemeanor. Here's my problem. And for me to even be considering a GPS tether with a house arrest, I'm a little irritated. The problem is, even with a GPS tether with a house arrest, she can go out on her front porch, and she was sitting out on that front porch watching them kids mess with this fence. So that's really not even an issue. So I'm kind of struggling with what is the appropriate, Ms. Stevenson, maybe, so I find that your client violated the bond. You may, because I'm trying to fashion a remedy that's fair, but she was sitting right on that porch watching the kids, and she would be able to do that with a GPS house restricted tether.
So here's what I want to say to the court, Your Honor. Upon review, So before we get to this morning, I'm of a totally different mindset. But upon review of the videos, I did have a very frank conversation with Ms. Brooks. And wherein I advised her that there's a very strong possibility that her inability to supervise these kids could cost her her freedom.
Absolutely.
So with that, India, who is not her child, who does not live there, who even according to the witness is not even over there that much, has not been and will not be over there. The other individual is Ms. Brooks' now 18-year-old daughter, Lauren, and I believe, Ms. Brooks has called me and tried to text me numerous times since our last court hearing, and she knows that this situation has gotten her in a place where her freedom is on the line. It is past, I don't get along with my neighbor anymore. We have stuff, it's past all that. Now, if anybody's going to jail, it's her. And I think she knows that, and I think she's very terrified of that. So I'm gonna ask the court, I believe that its assessment is spot on here. I'm gonna ask the court, we don't have that long before we get back here for the final pre-trial conference, but just to, Ms. Watkins knows that Ms. Ritter is a phone call away. Ms. Brooks knows that she's a phone call away from getting sent to jail. She already has the possible PPO violation coming up. I don't know if there's anything that's gonna come of it, but I believe that sitting here in this building since whenever she got here this morning, sitting through this hearing, not being in a position because of the upcoming case to even defend herself and offer an explanation, which I just don't even know if there is one right now. I think that this has been a sobering experience for me. I think that, again, she's got a chance to see herself as she came outside and didn't do anything to stop those kids. She got a chance to look at that. And I believe the experience has had a pretty chilling effect on us.
Now, okay, so this is arising out of an allegation of assault and battery. Does the 18-year-old daughter have any, okay, this is the question I want to answer to, but of course, I don't want it to be answered if it's going to impact the other case in any way, whether the 18-year-old daughter actually lives at the house. So, all right.
So Judge, just, put everything out there. Lauren does still live at home. And that's what I just asked Ms. Brooks. But Ms. Brooks has expressed to me that if that's gonna land her in jail, that will not be happening. Ms. Brooks is not trying to go to jail. Her daughter doesn't have anywhere else to live, but Ms. Brooks is not gonna be allowing her daughter to engage in the activities in the past. Ms. Brooks are
If I can just respond, just for the record, the people brought this to the court's attention, I believe, it was Friday. So Ms. Brooks was aware that the people received this information from Ms. Watkins. It's just bothering the people because it really is a safety risk, not only to Ms. Watkins at this point, but if there were anything to come as far as retaliation for the things that were just done, I believe it's really important for the court to understand the position that it leaves the people. And there is a pending case, I believe, or at least a warrant refused submitted to the office regarding the incident with her daughter. So at this point, they're just going to be coming back and forth, and with them being immediate neighbors, again, it just poses a safety risk as to, if there was something to possibly come to temperature, not saying that it is judged, but, I mean, I just want the court to understand what people stand at this.
Just, could we have sidebar? Please?
Yes. Oh, you wanna go in the hallway? Oh.
Judge Bryant's courtroom. Good counsel. Yes, I still have, let's see if I can cancel that one. It's either the personal or it's a cash bond, so I don't know if I'll be able to cancel this. Let me see. Okay, so. Give them September 18th. Let's go. Yes, sir. Yes, please. Give me my email address. Okay, it's Christopher, CHRISTOPHER. Got Flanagan. Frank, L-A. Oh, you have it? Okay. Yep. September 18th. Yep. And I'll put your appearance. All right, you want to go? numbers I've had.
All right. So. As I previously said, I think it's ridiculous. The neighbors can't be neighborly. Especially when the neighbors are some fully grown, with real past adulthood adults. So I don't know what started the situation. Sound like they haven't been neighborly for 5 years, which is absolutely and completely ridiculous nonetheless. This is what I think we have come up with as an initial adjustment to the bond. As I said, this is a misdemeanor. It is punishable by up to 93 days in jail, up to $500 in fines plus costs up to 2 years probation. Ms. Brooks is innocent until proven guilty as to the underlying assault matter. It would be a shame for her to sit in jail for 93 days and then be found not guilty. Now she's been in jail for 93 days. But I'm going to be clear unequivocally. And then let me also just say that I understand that there are cross complaints being filed and all of this. So my words are to both of you. Grow up. Grow up. Unfold your arms. Grow up. Grow up. Grow up. Grow up. Grow up. This is I don't even know how else to say it. Grow up. And stop this foolishness. I don't know who started it. But you're headed for some serious trouble if you keep it up. All of this petty betty stuff that I hear about that's going on between neighbors who live directly next door to each other. Grow up. Grow up. It's escalating. Let me say this. It's escalating. It has escalated. And you all need to stop. Because at the end of the day, you don't know who's gonna win. At the end of the day, you don't know who's gonna win. So stop it. Now, as it relates to this bond hearing, the 2 young ladies, it will be a violation of your bond, Ms. Brooks, and I will not hesitate to have you sit in jail pending this case. Those 2 young ladies have to go somewhere else. They need to go somewhere else. They're disrespectful. And I don't know if you have control over them or don't have control over them, or if you choose not to have control over them. Whatever the case may be, they were clearly seen on that video damaging that fence in whatever way, defacing the fence, pouring something on the fence. I don't know what it is. But if it occurs again, it's gonna get you locked up. It's gonna get your bond revoked. That little 14-year-old ought to have, I can't even say it on. That 14-year-old, I can't imagine a 14-year-old being out of my control. I can't even imagine it. It's like the concept won't even come into my mind. I mean, like I literally cannot imagine going outside and seeing my 14-year-old niece doing something, and I say, "What are you doing? You better stop it right now. Put that down." And they don't do it. Like I can't even imagine it. The concept of it, it just not can't come in my mind. So to sit back and say I don't have control over a 14-year-old, ma'am, that's ridiculous. Now, I'm looking at you, and what I'm saying in my mind is that you're at least my age. We at least equal, I think. If you're not exactly my age, I don't know. You look like you my age, at least. And if you can't have control over a 14-year-old, you need to reevaluate. And an 18-year-old that I don't have control over gets out. This is my house. If I don't have control over an 18-year-old, then you grown. You grown. So now you're gonna have to do something else because they're on the way of getting you locked up on a misdemeanor case. And if you get found not guilty, you still already been to jail. That's ridiculous. That's absolutely ridiculous. So I don't know the situation, but those two individuals, while this case is pending, are banned from the property. That's an addition of your bond. Do you understand what I'm saying? So if those individuals are at your place, now I'm not gonna kick the girl out like it be like when she go home, she gotta get out like in 5 minutes. So the complainant would don't call Miss Ritter today and say she's still there. Don't do that. Don't do that. Today is only Monday. Well, I feel like it's almost Wednesday, Thursday. Ooh. Today is only Monday. I don't know if she has somewhere to go. If you know, it's immediately where your 18-year-old daughter's gonna go, but I'm giving you until about Wednesday for y'all to figure that out. Otherwise, at the very minimum, I'm gonna add a GPS tether plus house arrest to you. And I'm probably gonna increase and make you post some type of monetary bond, because I'm not playing. Now, y'all seem like y'all playing with each other, but I'm not playing. And then let me say this, the contact provision is mutual. So something that I heard back in that back hallway causes me to feel like there may have also been a bond violation on behalf of the witness. Now, I don't know, because it was just mentioned briefly in the back hallway. But Ms. Watkins, let me be clear. Let me be clear. What would be a shame is for the witness to be locked up. Because I lock you up too. I don't play grown people games like this. If I say no contact, I mean that thing from the bottom of my heart. I mean it. I mean it. And it goes both ways. Because what you are not going to be able to do is throw rocks across the fence and then hide your hand behind your back and act like you the victim. That's what we're not going to do. But getting revenge or retaliating is also not what we're going to do. So I don't know who's right or who's wrong. But all I'm telling y'all is that the game better stop. Because if I hear about some more stuff, I'm gonna contact the prosecutor's office myself or the police department myself, and somebody gonna get their charges bumped up to some felony charges. Watch me. Now, I don't know who is gonna be getting the charges bumped up to some felony charges, but keep playing with me. And one of y'all gonna have some felony charges. And then it'll no longer be a misdemeanor, punishable by only 93 days. So you all better stop this. So at this time, I'm not going to increase the bond. I'm not going to revoke the bond. But I am adding to the bond condition that those two young ladies that I saw on this video are not allowed on that property. Now, notice I didn't say that Ms. Brooks cannot have contact with them. I'm not limiting her contact with her daughter in terms of her going to see them. I'm not limiting her contact with her niece in terms of her going to see them. What I'm saying that it is a violation of her bond if they come to that property and see her. Any questions?
No, Judge.
No, thank you, Your Honor.
All right, we're all set, we're all clear. Ms. Easton and Ms. Ritter, if you all could approach, I do have, I do have